5 or decade, everybody we are talking about the innovation. Now, I don't know my speakers will agree or not. Actually, real innovation has been from last 2 years when the pandemic came. Lot of things which have come which the people does not know. And the people are creating such a new innovation ideas, especially, for example, if I talk about the law, we never expected that we should not go to the courts by getting the justice from directly from the online. Again, this is an innovation which came in the pandemic period that a person can sit at home and here is whatever the case, whichever it is there. Other than that, there are so many innovations which is happening from last 2 years across the world in academics, in law, everywhere it is there. I think I'll not speak much on this because speakers are there to talk about the innovation on culture, how it will be there in India in the next. With this, I again welcome the keynote speakers, both the speakers, and my esteemed Dean, Dr. Egul Kishore, who is a legend in this law, and my young faculties, Saurabh, Siddharth, and the other professor which are there with us. And I welcome all the participants for this seminar. Namaskar. Good evening. Please.
Namaskar, sir. Thank you very much. अरे एकदम फ्लावर बुके का क्या हुआ?
Yes, sir. Can we start with inauguration ceremony, sir?
हाँ, inauguration ceremony होगी. आप सर को और सबको
yes, sir. Yes, sir. Yes, sir.
सर ये virtual flower है.
Virtual flower. सर ये तो virtual lamp है और अभी flower भी आ जाएगा. क्या करेंगे? So lighting of lamp virtually. Please enjoy it. So lighting of lamp from our esteemed guests. And then flower bouquet to our Honourable Vice Chancellor Sahab. And then flower bouquet to our most respected Professor Nareshwar Sahab. And to the other speaker, keynote speaker, flower bouquet to Mr. Rathore Sahab, but he has not come so far because he is in a meeting. He will be coming a little later.
We can present in absentia.
we are presenting in absentia. Sir.
Thank you so much, sir. Now I would like to invite Dean, Professor Dr. Yugal Kishore, to give overview regarding the event. Over to you, sir.
Thank you very much, Madam Galawat. Respected Vice Chancellor Sahab, Professor Muddu Vinayji, Registrar Sahab, Brigadier Raju Sethi, and my esteemed eminent expert and keynote speaker, and of course, a very good friend of mine, Professor Dr. Naresh Kumar Vatsji, and Professor Dr. S.P. Rathore in absentia. He will be joining after shortly. Madam Monica Kharola, the academic coordinator, system administrator, Mr. Akhilesh Singh ji, and the convener of this particular event, Mr. Saurabh Siddharth and Ekta Galawat ji, academicians from different parts of the country, professionals and student friends, Pan India. Today is a very auspicious day, that is 26th April 2021. Why it is auspicious? The reason is that in the year 2000 millennium year, World Intellectual Property Organization (WIPO) decided to celebrate World Intellectual Property Day on every 26th April 2020 onwards. So we have been celebrating every year. This year, especially the Mr. Tang, who is the Director General of WIPO, he has recognized the role of small and medium entrepreneurs and industries as the engine of our economy, particularly after pro-COVID situation. So after COVID era. And further understanding that these small and medium entrepreneurs, they lack much more in the knowledge and the benefits which they can get from intellectual property rights and law. And he has also very much realized that how much they suffer in their sustainability, growth, and competitive spirit, because they are not much well worth with the intellectual property rights. So therefore, this year the theme which has been chosen is IP, intellectual property, and small and medium entrepreneurship, taking your ideas to the market. So here on this occasion, the thrust is that small and medium entrepreneurs, they should be capable of understanding, they should be capable of applying, and therefore they should be capable of getting the benefit of intellectual property rights, and in which law plays a very important role. And on this occasion, I tell you, of course, it is I'm speaking here, but it's out of record, that it so happened yesterday I saw that many institutions, they are celebrating World Intellectual Property Day right on today. And then I immediately talked to my convener of the cell, of the Center of Intellectual Property Rights. अरे भाई सौरभ जी कुछ करना चाहिए, क्या हो रहा है, आप तो कुछ कर ही नहीं रहे हो. उनका ठीक है सर, कल एक लेक्चर कर लेते हैं, हम भी बोल देंगे. हमने कहा आप नहीं बोलेंगे, मैं अभी अपने परम मित्रों से बोलता हूँ कि वो मेरे लिए दो चार कुछ they should spare some time for me. And I was so overwhelmed when I talked with my professor doctor, a very, very eminent professor, very, very learned professor, and a very busy professor, and who happens to be the registrar of National Law University, Patiala, Punjab. That sir, can you spare your valuable time to speak to my students for a few minutes? He said, of course, I'm very busy, but I'll certainly spare time for you and your institution. So I'm really, really, really very grateful to you, sir. And at such a short notice, a dignitary, a person of eminence like you has spared his valuable time. It's really a very great thing. I will always be indebted to you, and I'm very much happy also, sir. And similarly, it so happened, and then after that, I discussed with another professor of mine, who is Professor S.P. Rathore, sir. He also said, yes, sir, I will be talking about. So, sir has decided that this year, because small and medium entrepreneurship, they lack a lot of confusion in the intellectual property rights with regards to the trademark. So therefore, sir has chosen a very, very relevant and important topic on this occasion, which is essential for the medium and small scale industries, and wherein we law students can play a very dominant role in getting their trademarks registered, promoted, and further protected. So sir will be speaking on IPR, promotion and protection of trademarks. And further, in the second, our second lecture will be there by Professor S.V. Rathore Sahab. He will be talking about Atmanirbhar Bharat, that is the culture of innovation in India during Atmanirbhar Bharat. And both the topics are so relevant for the theme of this particular year that I'm really very much grateful to both the speakers that they have chosen such a wonderful topic and have decided to enlighten and the participants here. Of course, normally we have a very good participation. First thing is time was very short, and second thing, now today I'm myself finding a great internet problem, and that is why I'm on mobile phone. So many of them are suffering, and then that is why the participation is little less. But it doesn't matter. I'm sure that what sir will be enlightening everyone, his words of wisdom will be there on you, and they can always enjoy and get themselves enlightened and acquire the knowledge which my Honourable Professor Sahab will be speaking here. With this, I take back to Ekta and Saurabh for the introduction of our Registrar Sahab. Our Registrar, of course, हमारे Registrar साहब यहाँ पे present है. मैं आपके बारे में बात कर रहा हूँ, पर साहब के बारे में.
Thank you so much, sir, for providing me the opportunity to introduce Professor Dr. Naresh Kumar Vats. Now I would like to start introduction. Professor Dr. Naresh Kumar Vats, sir, joined as a professor of law at Rajiv Gandhi National University of Law, Punjab, Patiala on December 22, 2018 and registrar with effect from January 1, 2019. Prior joining at RJNUL, Punjab Professor Vats has worked as a head of the Department of Law, founder chairman CPGLS, head center of IPR and Proctor. Professor Vats has been teaching intellectual property laws, family law, commercial arbitration mechanism and cyber law at undergraduate and postgraduate course at Maharashtra National Law University, Nagpur as professor. He also served as an associate professor of law at National Law University, Judicial Academy, Assam and BGC Trust University, Bangladesh, and as assistant professor of law at Institute of Law, Kurukshetra University. He has delivered many special lectures on taxation and business law in MBA course and refresher course in Kurukshetra University. He is the editor of various books and law journal. He has also acted as a co-organizing secretary of National Seminar and campus of Rural Lok Adalat and Legal Aid Clinic and coordinator of WIPO India Summer School 2017 between WIPO Geneva, Nagpur and MNLU and Nagpur, and will be hosting the WIPO India Summer School 2018 in the month of July 2018. Thank you so much, sir, for accepting our invitation and for enlightening us with your thoughts on this auspicious day. Over to you, sir.
Thank you, Ekta.
Sir.
Thank you, Vinay Muddu, sir. Professor Yugal Kishore, dear friend Saurabh ji, and all the students. Professor Yugal Kishore has spoken very high of me, sir, to which I don't feel that I'm eligible for it. But yes, I cannot deny I'm in your core heart. I'm your good friend, and we had been the good friend at Assam. Thank you for providing me the opportunity, and certainly Professor Muddu, Vice Chancellor Sahab, have discussed about the intellectual property. Okay, whether in the last 2 years the intellectual property has given a remarkable image in the society, no doubt. But what as a student of law, what I feel that intellectual property is the blood of everybody, is in every corner of the society, and this is the only and only resource of enriching as well as maintaining the finance, the nation, and the heritage. I'm proceeding whether my PPT is shared. Ekta, just
Yes, sir. Yes, sir.
see
Sure.
whether it's visible.
This is visible, sir. Very much visible.
Visible, sir. Thank you, sir. Thank you.
Yes, sir.
On the other hand, the topic which I will be discussing is the deceptive trademark and law of protection, particularly why the Trademark Act I have taken. This is one branch of the intellectual property. When we talk of the intellectual property, it contains many areas. Maybe the trademark is one part. The patent part is one part. Copyright is a different part. And the geographical indication, that is another part. And I'm concentrating on the trademark as a consumer. As a consumer, how we are getting deceived and what precaution we must take. Because particularly the trademark, when we are talking of this trademark on the patent, the intellectual property on the patent, that there we see there is a quid pro quo provision, actually quid pro quo relations. Yes, you reveal something and in consideration you have something. That is the consideration actually. On the other hand, when we talk of the trademark, in the trademark, it convey you the quality, it convey you the source of the product, the goods or the services. On the other hand, when we talk of the copyright, and the copyright that is considered as a negative right actually, and negative in the sense that is negative for the others, that not to copy, not to allow the copies without the consent of the author. On the other hand, the trade secret means so long as we continue maintaining that secrecy, confidentiality, that is your property, and moment the confidentiality is revealed, that is the public property. And for that, probably some other day we can have the discussion, okay, how to go ahead with the protection of the trademark, the trade secret, or getting it patented, or getting it otherwise, how does it come in the public domain. As a layman, when we consider it as a trademark, when we talk of the toothpaste has the many variety. It is a generic word, toothpaste. And if anybody is asked to get the toothpaste, so maybe the Colgate, maybe the Aqua, maybe the Sensodyne, maybe Close-Up, maybe some other quality, many more the brands are there. So that can be different unless and until we specify the particular brand. Whether my PPT is moving? Ekta?
Yes, sir, it is visible.
Okay, whether my PPT is rotating or not? Is it moving?
Yes, sir, it's moving. It's moving.
Thank you. When we go for the washing machine, means washing machine, we understand the utility of the washing machine. So different brands are there. Different trademarks are there. So go for the Whirlpool, go for the LG, go for Anida, go for Samsung, go for Blue Star or any other. Similarly, about the electronic gadgets like mobile phone, which is the common man need, maybe the Nokia, which was very old one and which is still grabbing the market in the majority of the people, or the Samsung or the Moto or the Apple or OnePlus or anything else. Laptop, similarly, different brands. Similarly, of the sweet, eatables, or otherwise the beverage like Haldiram, like the Coca-Cola, like the Pepsi, or the Rasna, or the Fruity, or the Fizz, or the flight services. These are some of the goods, but go on the services. like the flight services. These flight services may be by the Air India, Indigo, Jet Air, Emirates, or the Lufthansa, or the insurance services, maybe by LIC, maybe by SBI, SDFC, ICIC, PNB, car, Maruti, Hyundai. Miss, why I'm talking of that? Miss, thereby, take as an example, if you are a user of any of the product and you are going for the market as a layman, or you ask your boy or the girl, okay, beta, just you go to the market and the grocery shop and get me the toothpaste. The child do not know about the toothpaste and simply go to the grocery shop, ask for the toothpaste, and whatever the choice of the whatever is the product is available, simply hand it over. And the product, Mr. Service, the purpose and the object of the user is fulfilled until unless you are not specific of the particular product. But if you are very fan of the Colgate, you'll go for the Colgate. Otherwise, a common man understand you go for the toothpaste means that it's Colgate. You do not understand, okay, whether the Colgate is the trademark, or in place of the Colgate, even the Aqua can be given. Will you accept it? Will you accept Sensodyne? Will you accept the closure? Means the purpose is at least fulfilled by giving the product. But until unless you see the mark, you read the mark, you identify the packing. So that question is there actually. And similarly in relation with the other product, as when we go for the preamble of the Trademark Act 1999, the preamble, it specifies when it was reenacted and amended to act and to amend. It means considering that some act is there prior to the 1999 and the purpose was to amend it, means somewhere some gap was there, and to consolidate means thereby something was still unconsolidated, something was still lying in the, at least in the form of the corrigendum or in form of the some bill or some in form of some amendment. And that is relating to the trademark, and to provide the registration, specifying that registration is very essential for the protection of the trademark. For protection of the trademark, that registration is mandate, except that well-known trademark. Before that, it is not registered, but it is in the market and the people knows, okay, yes, this is the well-known trademark. There, the essential is not essential, but it is accepted. Okay, yes, all the rights and the rights are attracted by the well-known trademark. On the other hand, then go for the goods or the services, and even the prevention of the use of the fraudulent mark. Now the question is, okay, yes, because of the well-known trademark, because of the unregistered trademark, and simply because these are the consumer-friendly products, consumer usable products, and if it is a consumer usable product, it means the consumers can be deceived, they can be frauded. So to avoid that fraud, to avoid and to avoid the deception, so the provision is there. Okay, yes, this should be the provision, and this should be the provision of the registration of the trademark. So this way we are going ahead identifying, okay, what is that trademark. Initially we understood with the name of the goods and the services, okay, these are considered as a trademark. When we really identify, we go for the definitional clause of the trademark. It is considered as one of the area of the intellectual property, and the purpose is, yes, the either to identify the goods and the services. And how the goods and services are identified? Somewhere the quality is maintained, as well as value of the product is maintained, and as well as some image, with the help of that image, relating it with the manufacturer, relating it with that particular the proprietor. Okay, who is that proprietor? Who is the merchandiser? On the other hand, then identifying the preamble. Yes, the preamble is just to consolidate and to amend the law. Before that, of course, the information technology provision, like the virtual trading was very, very low, and it was not a part of the Trademark Act. So that provision was considered, that was incorporated. Okay, even if sitting at one place, you can make the transaction across the world. And therefore, for the making the transaction, at least the images and the graphical representation, with the help of the graphical representation, you can design and you can send the images, you can go and just catch the customers. So this was the purpose of the trademark. And on the other hand, when we go for these examples, like the trademark, type of intellectual property, and as well as a brand name, as well as it is indicating and making a distinction, okay, the product of X and the product of Y, services of X and the services of Y, which is more visible and more clear to the consumers, identifying and distinguishing their need and the services and the product of the others. With the help of these signs, these symbols, these logos, how it is, okay, like the Maruti car, it has the trademark Maruti by name, or the word like a name Maruti, or the word burger, or otherwise phrase kar lo duniya muthi mein, means if you identify ki kar lo duniya muthi mein, it means it is somewhere related to the particular the service provider, or otherwise a logo of Volkswagen, or the symbol Apple symbol, simply Apple symbol, or the Twitter symbol, or otherwise a design of maybe the Adidas, or otherwise an image like the Nike, or combination of the word, or combination of the design and the word. So that is what it is giving the mark by identifying either with this symbol, this logo, which is encircled W, as well as this tri-leaf Adidas, or otherwise this Apple. So it indicate, it give you the message that this is what the particular product it is related. Section 2 ZB of the Trademark Act, it simply identify and define the trademark, that the mark which is capable of the graphical representation, which can be represented graphically, and which is capable of distinguishing the goods and the services of one person from the goods and services of the other person, and the shape and their packages, and the combination of the colors. Or the trademark is which is considered as a personality of the trader or the convener of the image. When we are going for the personality as a trader, because everybody in the market wanted to survive. If you are a manufacturer of any product or the supplier of any services, you will do your best to stay in the market. If you are doing excellent, market will accept you. If you try to deceive the consumers, consumer will say thank you, and you have to pack up your luggage. You have to sit at home. So therefore, that is the personality is there, and that personality, it give you a yes. If I ask the Nike, it means yes. The person who is a manufacturer, the person who is a merchandiser, how the person can be, or the sponsor, how the person can be. So that is the image is conveyed there with the help of the product. Or simply I discuss with the friends on the students, okay, if as a man being, means if I am well behaved, well presented in the market, means the assessment can be drawn, inference can be drawn, okay, yes, definitely I have my back, different. Or the person, he is not well versed, person who is not having, means the personal life even. So that is related therein as the convener of the image and the personality of the trader. And on the other hand, like the trademark identifying which is the trademark, which is a registered one, which is unregistered one, the service mark. So these are the marks which you will find. The TM, which is encircled, which is considered as a TM while applying for the application, TM application. So that time it is until unless it is not finalized, it is not notified by the trademark registry or the SM, that is the service mark, unregistered service mark. And when you get everything done, then the R is encircled. You'll find the product which is encircled R. Along with that, the people get confused as a consumer with the associated mark. And for that purpose, the associated trademark is incorporated under section 2C. Okay, yes, there must be to protect the interest of the consumers. As associated trademark, that says the trademark deemed to be or required to be registered as an associated trademark. As if you take as an example of the PepsiCo. PepsiCo, the bottle which I have shown you here it is. So you understand Pepsi, the bottle container and the Pepsi. So you just keep it in mind, okay, how this word mark of the Pepsi was filed in 1994. And the mark, it was in 1997, the Pepsi. So both the trademark are filed in the same class with the same specification of the goods, obviously by the Pepsi, to just eliminate the confusion. The registry has accepted this because the Pepsi trademark and the word mark should not be the different, because the applicant is the same, manufacturer is the same, and the consumer should not get confused how it is. On the other hand, when we are talking of the section 9, absolute refusal. So absolute refusal will be, yes, there should be very clear distinction between that mark when you are filing an application for the trademark. And therefore, the trademark has accepted this registration, combination of the mark and combination of the logo. As on the other hand, the collective mark, there may be another confusion in the mind of the consumers. Keeping in mind different persons are there, and just for the purpose the collective and deceptive similarity, how they are somewhere related to eliminate the deception. The collective mark under section 2C, that says the distinguishing the goods and the services of the members of an association of the person, not being a membership within the meaning of the partnership. They are not the partner, but they are a member of the body, like the chartered account, like the Bar Council of India. Means that is a body, and everybody who is registering themselves as an advocate, as a chartered accountant, and they are using the CA like this mark. So this is the collective mark. Everybody is working under the particular mark, collective mark. But how they are performing, that is the different work. But to avoid the confusion, everybody, there are many advocates, maybe the criminal, maybe the civil, maybe the criminal and civil, maybe the taxation. So everybody deal with the different areas. Or otherwise, like the collective trademark, it is owned by an organization like the CS, like the BCI. It is owned by the organization, but the mark is used by the member to identify themselves. They are using themselves as a logo, as a member of that body. And certification mark, that may be used by anybody who complies with the standards defined by the owner, like the ISO. That is another certifying. Okay, what quality you maintain, like even the neck, like even the NBA, like the examination which you are taking time to time, and your examination or the controller is evaluating. This is what the grade you are having. That is the certification. Okay, based on that, this criteria, you have been assessed this particular grade. So this way, on the other hand, how the deceptive trademark is there? Deceptive similarity means the consumers, how they are caught, they are made fool of by the merchantiser. Those are not taking the appropriate step and trying to deceive the society. Under 2H of the 1999 Act, Trademark Act, the deceptive similarity that says a mark shall be deemed to be deceptive similar to another mark if it is so nearly resembles that other mark as is likely to deceive or cause the confusion. Just an understanding, if I ask my friends, the audience, the trademark of Apple, if you understand Apple, okay, what is that Apple trademark? Which way or which side the cut mark is there of the apple? If somebody can just if I ask the user, they themselves sometimes get confused. Of course, may not be very difficult, may not be possible that everybody start responding it. But if I ask
our left side and Apple's right side.
Apple right side, very wonderful,
Apple's
wonderful.
right.
And left side is
Ours left side. Ours left side.
Okay. So yes, you are right, sir. Thank you. Usually it's very, very, very important actually because you are the user. But sometimes the person, those are not the user of the Apple gadget. So sometimes it may be confused to them which side the cut mark, usually left side or right side. But for your kind information, I have one item which is having the left side cut mark. And that is just for the to show at the time of the lecture. Actually, it is very difficult for me to show you, but surprising, and that is surprising. People get caught of it. As a law student, when there was an incident with us, me and my vice chancellor was traveling. Both were traveling at that time. In some of the train, the person came and just handed over the water bottle, actually, simply water bottle, and the Bisleri in place of the Bisleri. But when I started reading it, it is not a Bisleri. So it was some phonetical similarity, Bilsari, and that is got confused. So the typographical somewhere some rearrangement, like the Colgate and the Colmate. It's a replacement of a G and M only, but the package is there and everything is there, the Colgate and Colmate. So you will understand how the things will be the very deceptive similar. Like, but who is the right person to understand, to let you know? The consumer are the right person, like the deceptive similar, to establish the fact, the consumer are the right person to know the right thing and the wrong thing. And therefore, the very cautious decision that is by the proprietor in relation, the deception may be in relation to the goods, in relation to the origin, in relation to the trade connection. Like I was saying about the trade, the apple. Apple means somewhere some trade relation and the relation with the owner actually. Having that impression, yes, this particular product is also manufactured by the particular Apple owner, but whereas it is not. It is not. And for that purpose, the proprietor has to be very cautious. Proprietor has to make an arrangement for the survey time to time and show that my product is doing well, whether my product is getting somewhere hampered or some competition. Like sometime as a parent, we go for the school, attend the parents meeting, and we understand, we get the feedback how my child is doing. So this way kind of the tactics, this way kind of the conduct, the proprietor and the owner, they must do in the market and have survey, not personally, but get it done through somebody, get it done through the researcher, get it done from the students, and to filter and to eliminate the rock. On the other hand, like this Nike. So which one is better? Which one is the correct one? Nike. Maybe this one, maybe this one, maybe this one, or maybe this apple, or this apple, or this apple. Why not this is also apple? And here is a cut mark. Here is also a cut mark, but the color is the different. If you have somewhere protected your trademark with the color openly, with the different use, like the Pepsi and the PepsiCo and the container, separately, even separately, if you are using, you are at liberty. Similarly, McDonald's, means the right side click of the Nike, left side click of the Nike. Here is the Nike. It is not a Nike, but Nikah. And here is a Nike. And here is also Nike. Reverse side right. So people get confused. Like even the Lakme and Subhas trading case. Here, the Lakme plaintiff was selling the cosmetic product under the trademark name Lakme, and the plaintiff was also selling the product under the name Like Me. So defendant here, the Like Me and the plaintiff under the Lakme. Lakme is a well-known trademark. So just a phonetical similarity is there actually. So considered when the case went to the court considered, okay, no, because the alphabets used in the Like Me and the Lakme, because everybody is not using the Like Me. It is the particular class actually. And that particular class, whoever is using, they are educated, they understand what is the Like Me, what is the Lakme. So to that extent, it is tolerable, it is considered, okay, yes, there is no deceptive similarity. But when we are going for this, the SM Dicam Limited versus a Cadbury, again here it is considered the picnic and the picnic. So considering, okay, yes, considered because the spelling is the different of the picnic, and here is the PIK and IK. So the defendant is not causing any deceptive similarity. So both can exist, both have their independent identity in the market. So it is tolerable to that extent. If we go here, particularly the Cadila Healthcare and the Cadila Pharmaceutical product, here at particular time, both were together, but because of some difference, they separated themselves, and the dispute arose on the issues, okay, who will use the particular trademark. Both started using Falsitab and the Falsigo separately, and the dispute arose, okay, because both the particularly the medicine, injunction, both the medicine is used for the same disease manufacturer. So it is very difficult for the consumers to identify what is the Falsigo, what is the Falsitab. Composition of the Falsitab and the Falsigo both are same. Uses of the Falsitab and the Falsigo are the same. But the court has taken it very seriously, considering that defendant claimed that the prefix Falsigo and Falsitab has been derived from the name of the disease Falciforma malaria. And considering that, because we are living in that particular society, we have not yet grown, because the fabric of the society is not that much mature, and particularly in the medical field, it is very risky to have the deception, it should be very, very clear. Person must be very clear. So the difference must be there, and consider that yes, even the phonetical similarity is there, and you have to stop it. Injunction was given, and it was stopped using that falsi. Go. Similarly, about the MS Allied Blender and the Distillery Private Limited versus the Govind Yadav NR. Another. In this case, the plaintiff claimed that the defendant trademark Fauzi is a deceptive similar to that of the plaintiff words officer choice. Now the question arises here. Okay, one is having the plaintiff the Fauzi trademark on the liquor, and on the other hand the officer choice. And here the consideration by them is one is saying in Hindi Fauzi, and the other one is the officer choice, which is used in the military alcoholic beverage. Though the trade dress plays important role in the deciding which is Fauzi and which is the officer choice. And considered yes, the trade dress is the different, even the name is also different, as well as the trade dress is also different. So there is no as such deceptive similarity. On the other hand, like this case, the Win Medicare Private Limited versus Galfa Laboratory Limited. The plaintiff manufactured the microcidal solution, surgical scrub, ointment, germicidal, gargles, and various other pharmaceutical preparations under the trademark Betadine. Betadine, very well known, and which were sold in the various packages, including the tube, bottles, jars, and the carton. In May 2013, the plaintiff noticed that there is another competitor in the market, which is with the name of the Betadine M, and the plaintiff filed an opposition. Considering that the court taken its own decision, there is a likelihood of confusion, and they concluded that there is a risk of the confusion. The court held that where the defendant mark contained the essential feature of the plaintiff mark combined with the other matters, and the court held that it was beyond that doubt the defendant had knowingly adopted the deceptive similar mark, as was evident from the identical trade dress, color, and the similar package, as well as which was used for the similar kind of the disease, and the medicine was also composing of the same kind of the mixture solutions. So, Mr. Considering that the court is very, very, very particular, particularly in the pharmaceutical products, somewhere some kind of the phonetical similarity, deceptive similarity is there. So they want it should be very, very distinguished one. Even as a layman, they must be very clear that there should not be a confusion in that particular the name of the trademark. They are also even considered as the passing off in the name of the well-known trademark, like in the case of the Cadila Healthcare, Cadila Pharmaceutical. So having that case, yes, it was well established, and you can pass off your product falsity, under the well-known. People accept that Cadila Healthcare product is manufactured by the particular proprietor. And similarly, like in the Amritdhara Pharmacy and the Satyadev Gupta, respondent applied for the trademark in the chemical preparation, Lakshman Dhara, in class 5 in the Kanpur, sold throughout the Indian and the worldwide market 1923 onward. On the notice of the register, Amritdhara Pharmacy filed opposition application. It is registered in 1901 and has great popularity in the market. The medicine Lakshman Dhara and Amritdhara being the same nature and the quality. But when we are considering nature is the same, but on the other hand, when we go for the trademark Lakshman Dhara and Amritdhara, considering they can be refused. It can be identified, it is Lakshman Dhara, it is Amritdhara. Differently, it is, of course, Lakshman was Amrit actually. It was Amar by Lord Hanuman. जो बूटी लेके आए तो मतलब he became Amar, Lakshman. So with that name actually. So this way we cannot just pass off the product, but consider that no, it is not passing off. It is, they have their own identity. Similarly, if we go for the well-known trademark, so this is also somewhere causing confusion. But to establish the well-known trademark, it is very essential. We have to establish the mark, whether it is a well-known trademark. Different criteria are there, and that way, like if we go for the section 2 ZB, the definition that says in relation to any goods or the service, means a mark which has become so to the substantial segment to the public understand it, and it has become substantial segment for the public, which use such goods and the receive such services, that the use of such mark in the relation to the other goods and the services would likely to be taken as indicating in connection with the course of the trade or the rendering of the services between those goods and the services, and a person using the mark in relation to the first mentioned goods or the services. Means if somebody is giving that, naming that, okay, automatically or somewhere the impression goes in the mind, okay, yes, okay, you are talking of that thing. Like I was giving you an example, okay, Colgate. And somewhere if I send somebody, a layman, a baby in the grocery shop we go, okay, give me the Colgate. Okay, you want toothpaste. Means the click directly, it clicks in the minds of the grocery shop. Okay, yes, you want the toothpaste. Immaterial, he or she has the Colgate or not, but he will give you the toothpaste. Maybe the Sensodyne, maybe the Pepsi, maybe anything else can be. Basic Dant Kranti, Babaji wala Dant Kranti. He has to give something. Immaterial, you are concerned for the Colgate. But because it has attained some distinction in the mind, it has attained that acknowledgement in the society. Like in the case, very particularly, very famous case, the Whirlpool Corporation in the Anardore case. Considered that, yes, the name Whirlpool is associated for the long, much prior to the defendant application 1986, held by the court that the Whirlpool Corporation, in view of the prior use, he himself, the Whirlpool, was the prior user of the particular trademark. And the trans-border even reputation extending even to India. The trademark Whirlpool gives an indication to the origin of the goods as emanating from the relating Whirlpool Corporation. So it has somewhere related it to it. But later on, somewhere because of some reason, the Whirlpool could not continue. Meantime, after some time, could not renew. But meantime, sometime, the Chinar Trust has registered it, filed it, and Chinar Trust got the trademark. When they went to the court, in the court held that no, it is not. Even they could establish that yes, this is what, of course, we were not directly in the market, but we had been supplying the product in the US Embassy. And consider that High Court has recorded its satisfaction based on the argument that the use of the Whirlpool mark by the defendant indicate prima facie an intention to pass off the product, indicating that when you started, even the Whirlpool could not come in the market as you understood. But having that, after the 5 or 6 years, you started manufacturing and naming your product as the Whirlpool. Your intention is to pass off your product in the name of the Whirlpool, because the Whirlpool has attained that distinction in the market. So this way, the court held that no, it was your clear intention, and your intention was to pass off that product. And likelihood is that yes, you are misleading the consumers. On the other hand, when we go for the COVID situation, actually, we could analyze in the COVID situation, almost 150 COVID related trademarks have been filed in the either medicine or related the vaccine, corona. And considering as per the trademark registry, the Glennsmith Lab was the first company to file the pandemic reference trademark, COVID relief trademark. This Glennsmith on March 5th, 2020, Bharat Biotech filed its trademark COVID vaccine, like the COVID Act on 12th March, and Coroflu on 19th March, and the Covidum by Swiss Garner Life Limited, they filed on 30th March, and Covidoxil filed by Alkaline Laboratory on 30th March. The trademark medicinal and the pharmaceutical operation, the Favikovit 200 and the Covidang 3D. Means many more, almost the 150 trademark have been filed related to the COVID relief, COVID medicine, and COVID vaccine. But the question is here, okay, the similar situation was there when in the 2015 there was an outbreak Zika virus. During the Zika virus there was an outbreak, and during that period this Tata Motor, they also started naming their product with the help of the name of the Zika virus. Similarly, like Zika virus was there, they named Zika, they named Tiago. And if we go strictly as per section 9 of the Trademark Act, that says when the things have become customed as section 9 1 clause A, that says an identical or similar wording, so we cannot accept the trademark. There is a possibility we cannot accept. Now, some name must be there, like even the generic. I was saying the apple, his name is generic, but the purpose of the apple is indicating the electronic gadget, not the apple vegetable. You go for the corona, but maybe the corona sweet. So this way, when the penalty provision is also there actually to protect the trademark merchandisers and the fake on the false users of the trademark, section 103 of the Trademark Act, it states that who falsify any trademark, wrongly and falsify the trademark, or falsely apply the goods or the services, any trademark, or otherwise who makes or dispose of any of the product with the particular die or the block or the machine or the plate or any instrument with the falsifying trademark, or who applies the false trade description on the goods or the services, false trade description which is not registered under 2ZZ, or which is contrary to section 9, or otherwise who tamper with or alter or efface an indication in the origin which has been applied to the goods or the services, and who causes anything above mentioned, the above mentioned act shall be punished and imprisoned by the at least 6 months of imprisonment, and which can be extended to the 3 years, and the fine up to 50,000, which can be extended to 2 lakhs. So for this, I thank you all the listeners bearing with me, and thank you ICFAI family, specifically my friend Professor Yugal Kishore, Vice Chancellor Mudhu sir, Saurabh ji, Ekta ji, and all the students. Thank you, sir, providing me the opportunity.
Thank you so much, sir, for explaining this topic beautifully and also interrelate with the current pandemic situation. Now, I would like to invite Mr. Saurabh Siddharth, sir, for the introduction of Professor Dr. S.P. Rathore, sir. Over to you, sir.
एक मिनट बेटा मैं
Yes, sir, yes, sir. Yes,
I'll
sir.
ask Professor Wat Sahab,
जी सर जी.
will you be here or will you be leaving?
Sir, I'll be here, sir. Don't worry.
हाँ मतलब एक्चुअली क्वेश्चन आंसर में होता है ना सर.
हाँ.
अगर आप पूछ रहे हैं तो फिर हम उसको उनका भी कर लेते हैं, फिर एक साथ क्वेश्चन आंसर कर लेते हैं.
No matter. I'm sitting my office actually.
Very kind of you. We are very much grateful to you, sir. ठीक है सर, ठीक है सर, ठीक है. हाँ तो फिर शुरू कर लीजिए. हाँ अब उन्हें सर को बुला लीजिए. सौरभ जी. हाँ
Yes, sir.
सर है ना, सर आ गए हैं ना, देखा आपने?
Yes, sir.
हाँ
हाँ राठौर साहब है.
So, I would like to introduce you all to a very informative session we have been through. And myself, IPR enthusiast, I actually loved the session. I would like to next call upon Professor Dr. S.P. Rathore, who started his career as lecturer of law in 1996 itself. And he became professor in 2012, having 25 years of experience, having guided 13 PhD scholars and 8 more are pursuing it. And he has presented 50 papers, and he has been the vice president of All India Law Teachers Congress between 2001 and 2003. Currently, he is heading as professor in Gujarat University, and having published more than 30 articles in also in his corpus and UGC care list. And he is also presently the member of the Board of Studies and member of faculty in Gujarat University and MS University of Baroda and one Central University at Wardha, Maharashtra. We cordially welcome you, sir. You are such a think tank that your introduction is still, sir, cannot be completed in few words. So we cordially welcome you, sir.
Thank you, Saurabh, for nice introduction. Professor Goodself Sahab ji, namaskar. And my namaskar to Register Sahab, Professor Watts.
Thank you, right now. Seeing you virtually, looking forward for physical meet.
Definitely, sir. We will look forward to meet again somewhere physically in your university at least. Definitely.
Certainly.
Shall I start, sir?
Sure, sir. Sir, a few questions, sir, if you may, sir, permit us. Few questions participants they want to ask. Is it comfortable for sir? Sir, unmute, please unmute, sir. Dean, sir, please unmute.
The questions to me? Hello, Saurabh?
Yes, sir. Soon our Professor S.P. Rathore, sir, started speaking. The question sprang out of nowhere.
Okay.
So, Dean, sir, is it fine, sir? Okay. Sir, we can't hear you, sir. Please unmute yourself.
Saurabh, Dean sir said that the questions.
Is it questions for me?
No, sir.
Question
No.
for star, sir. Question for a star, sir. Our first speaker.
Yes,
So,
please.
will it be
please,
okay?
please.
नहीं ऐसा है सर अभी आप रुक रहे हैं तो बाद में क्वेश्चन एक साथ ले लें अगर आप परमिट करें तो.
We will take the questions together. Sure.
हाँ we will take the question
Please
together.
continue, sir.
Moment.
Please continue, sir.
No matter.
Please continue.
So we regret, sir, our Rathore Sahab, that we have a little confusion. So please do not mind it and please start your lecture. Because we are all here to listen to you.
It's okay, sir. At the outset, let me thank the ICFAI University and ICFAI Law School for organizing this workshop on intellectual property rights and giving me this opportunity for sharing my views on assessing the innovation culture in India for Atmanirbhar Bharat. My special thanks to go to Professor, of course, Yugal Kishore Sirji for giving this opportunity, and of course, my thanks to the team also, of course, Saurabh and Ekta, because I have seen that they were there in that organizing committee. Before starting this, my views on this innovation culture, because you see why I have chosen this innovation culture for Atmanirbhar Bharat. As you know, ever since in May last year, in 2020, the central government came out with a phrase that is Atmanirbhar Bharat. When the Prime Minister spoke on Atmanirbhar Bharat, everyone looked after what is Atmanirbhar Bharat, how we are going to achieve. At the same time, the government has targeted to achieve this 5 trillion economy by 2024, this present government. So there is a relationship between this Atmanirbhar Bharat and this 5 trillion economy also to some extent. But let me contextualize this Atmanirbhar Bharat with this innovation culture. Otherwise, I will go somewhere else also, because this Atmanirbhar Bharat has many connotations. But as far as my understanding of Atmanirbhar Bharat, for this patent regime or intellectual property rights regime, I understand that Atmanirbhar Bharat means self-reliant. Self-reliant means non-dependence. This is not possible in this present world. You cannot, without dependence, you cannot do any business at all. We have to depend on other countries and other products also. But at the same time, there should be less dependence on other products, other countries' products, foreign products. And we have to make ourselves Atmanirbhar, so that we will be less dependent on other countries, so that our economy will grow and we can export our products to foreign countries. In that way, we can also achieve this 5 trillion economy by 2024. Leaving apart that from that Atmanirbhar Bharat, let me, that in that case, when the question comes, are we prepared with this Atmanirbhar Bharat? The government has come out with a proposal and they have already drafted the many policies regarding Atmanirbhar Bharat. Question comes whether we are in a position to achieve this Atmanirbhar Bharat is perceived by the government, present government. And for that reason, on this World Intellectual Property Rights Day, I have chosen this topic, that let me assess or evaluate the innovation culture in India, whether this innovation culture in India can take us to that goal, higher goal of Atmanirbhar Bharat. And for that, hence I'm discussing my views on this Atmanirbhar Bharat, and let me thank everyone, or let me congratulate everyone for this on this World Intellectual Property Rights Day. To begin with my presentation, I have discussed this Atmanirbhar Bharat from many perspectives. Question comes when when innovation culture is concerned, then question comes, what do you mean by innovation? Then innovation is nothing but is the process by which ideas are generated and commercialized. Question comes, invention and innovations are two different things. When you have an ideas, and if the ideas are being generated, and if you are in a position to commercialize those ideas, then definitely that will lead us to innovation. Today's globalized landscape, innovation is often associated with progress, because more the innovation and more the innovative people of a country, that country definitely have a more economic development. And that is how we look at the economic developed countries, because they have more innovative ideas and more innovation with them. To innovate is a survival instinct compulsory to stay relevant. You see, in the present day context, if you want to stay relevant in a global market, you have to be always innovate yourself, and it's a continuous process. So for me, innovation is nothing but it's an invention plus exploitation. Because when you are coming out with an invention, that may not lead us to innovation until we exploit that invention, or we commercialize that invention in a greater number, then only you call it innovation. So from that perspective, I am discussing this innovation culture in India. Before going to that, let me take you to the innovation culture across the globe. What is the innovation culture across the globe? Relying upon the Global Innovation Index 2020, because this Global Innovation Index 2021 is yet to come. According to this 2020 Innovation Index, the 10 best ranked innovative countries of the world are, look at the things. At the number 1, it is Switzerland. Number 2, at the number 2 is Sweden. Followed by at number 3, United States of America. At 4th number is United Kingdom. 5th is Netherlands. 6th is Denmark. 7th is Finland. 8th is Singapore. 9th is Germany. And 10th is Republic of India. You see, out of 10, most 6 or 7 countries are from European countries. Except for United States of America, then this Singapore and Republic of Korea, all other countries are from European Union. Otherwise, also you see this concept of industrial property or intellectual property, it was developed from European countries. They are industrially developed from the beginning itself. And that's the reason, if you go through the international instruments on intellectual property rights, you will see always only the initiatives from the European countries, whether it is the Paris Convention of 1883 or the Bern Convention of 1886 or Rome Convention or everything for that matter. Most of the cases we have seen that the lead played by the European Union is enormous. But coming to that, my point again, if Switzerland is the #1 country of most innovative country of the world, look at the population of that country. The population of that country is only 87 lakhs. Sweden, the population is 1.03 crores. USA, it is of course 33 crores. UK, 6.79 crores. Netherlands, it is 1.71 crores. Denmark, only 58 lakhs. Finland, 55 lakhs. Singapore, 56 lakhs. Germany, 8.37 crores. And Republic of Korea, of course, 5.12 crores. What is suggest? You look at the thing. The population wise also you see they are just like small metros or metros of Indian country of India. Some of the metros are much bigger than these innovative countries. We are having 1.3 billion people, that is 130 crores plus population in India. The government usually says that we have 130 crores minds. If we are having 130 crores people, we are having also 130 crore minds, but we are not using that minds to convert into innovation. That is the biggest issue one is to understand. Now coming to my next slide, you see, if you look at the what is the India's ranking in Global Innovation Index, again, it is as per the 2020, somehow we reached to the 50 club of 50 in 2020 because we are placed at 40th position. If you look at because I have taken the 5-year statistics only. In 2016, we were at 66th position. Slowly, we improved to 60 in 2017, 57 in 2018, 52 in 2019, of course, in 48 in 2020. Let us hope for the best how we are performing in the 2021 Global Innovation Index. This Global Innovation Index tells us how innovative we are as far as innovation is concerned, because ultimately the innovation has to be linked with the patents, not any other intellectual property rights for that matter. Intellectual property rights have many other intellectual property rights, exactly what my the former speaker has talked about the trademark. It is also an important aspect of intellectual property rights. Apart from trademark, copyright is there, related rights are there, then GIs are there, semiconductor integrated circuit layout designs are there, designs are there, all these intellectual property rights are there. But my concern is, because I am discussing on innovation, I will be concentrating on only patents. Now you see, what is the innovation culture in India? For that, again, I have relied upon this annual report of Intellectual Property India of 2018-19, because this is the only latest annual report that is available with us. In this also, I have taken the 5 years statistics where we stand. As far as I'm talking about trends in patent applications, I'm not talking about grant of patents, because in this you can get a sense how many patent applications we are filing, because that shows how innovative day by day we are, by year we are. So in that case, if you look at the 2014-15, only 42,763 patent applications were filed. In 2015-16, it was 46,904. Again, it was little bit came down in 2016-17. It came to 45,444. Again, it rose to 47,850 4 in 2017-18, and of course in 2018-19, 50,659, because 1920 and 2021, 1920, of course, that will be available, but is not been published by the Intellectual Property Rights Property India annual report. So look at the things again. In that sense, again, I'm working on, I'm discussing what is the patterns of filing of this patent application by state-wise. If you look at the state-wise applications filed by Indian applicants, in that sense, I think Maharashtra is the highest number of 4,197 in 2018-19. Again, I'm talking about 2018-19. I'm not talking about the latest 1920 or 2021, because this is the latest statistics available with me, and for that matter for anyone also. So Maharashtra is having the highest number of patent applications that were filed in 2018-19. It is 4,197, followed by Tamil Nadu 2,382, followed by Karnataka 2,113, like that Delhi. When I'm talking about my state, it only 858, Gujarat. And you see the Assam has only filed 109 patent application. I'm making very clear, only patent applications have been filed. That does not necessarily mean that every patent application will be turned into grant of patents. Now look at the thing again. If you look the top 5 Indian applicants for patents in the field of information technology, because it is only one of the important field where most of the applicants, applicants are being filed. In that case, you see TCS is number 1, followed by Wipro Limited. But interestingly, we saw that Chandigarh University is ranked at 3rd position, and Chandigarh group of colleges in 4th position, and Indian Institute of Technology collectively, there are around 20 to 23 IITs are there. Collectively, they have filed much less than this Chandigarh University in that sense, if I'm talking about any institution. So again, I have relied upon this annual report of 2018-19 of Intellectual Property Rights. So in comparison to that, because this year's annual report does not reflect the applications filed, but in 2017-18, Wipro Limited filed only 125 application, and it stood number 1. Tata Consultancy TCS service only with 90, it was 2nd position. And then of course at that point of time, this Punjab University or Punjab group of colleges or the IITs were not in that race in that. So the scenario has been changed. So if I'm talking about the top 5 Indian applicants for patents in the field of information technology, case study I have taken. Now coming to the top Indian applicants for patents from scientific and research and development organization, because we are so much proud of our scientific institutions such as CSI. It has been number 1 right now as far as patents applications are filed in 2018-19. Maximum number of patent applications filed by any scientific organization. Then Council of Scientific and Industrial Research stands for number 1. You see, even we are so much followed by the Sci Institute of the Technology and Engineering Research, followed by at the number 3 it is Defense DRDO, at number 4 it is Indian Institute of Science, number 5th is Indian Council of Agriculture Research, ICAR. Likewise, you see, look at the things. So these are the 10 top Indian applicants for patents from scientific and research development organization. This is so again giving a sense. In the same, in 2017-18, the CSI with 176 applications, they were the number 1 applicant, scientific and research development organization was there. Followed by a Defense Research and Development Organization, 126. Look at the number is not that encouraging I'm talking about, because 2018-19, I could not get the number of applications that were filed by these top 10 this scientific and research development organization. This is there. We can go through the this annual report. You can get also. I'm not talking about anything new from this. Now coming to the, when I'm talking being a teacher, I'm more concerned about the top Indian applicants for patents from institutes and universities. If I'm talking about how much that are filed by the universities and educational institutes, in that case, Indian Institutes of Technology collectively, they stood at number one, followed by the Chandigarh University, and of course, at number 3, Solon University, 4th is Amity University, 5th is SRM Institute of Science and Technology, 6th is Chandigarh Group of Colleges, like that. So in contrast to that, in 2017-18, Indian Institute of Technology collectively, they filed 540 applications only, patent applications, followed by MIT with 119, and other, many of them have not even crossed the 3-digit mark. Now look at the things. Now in this, I am telling you something. If you look at the foreign applicants, by patent applicants by foreign applicants, in that case, Qualcomm Incorporated is the number 1, followed by Samsung Electronics, Huawei Technologies of China at the 3rd. Likewise, you see, look at the things. Now, in contrast to that, if you look at the 2017-18, you see Qualcomm Incorporated filed 960 applications. You see, this numbers only single foreign corporation. It filed 960, whereas our top 10 applicants, universities and institutions, they together they could not reach that mark. What is why I am showing these things? That because a corporation, multinational corporation, single-handedly they are filing this much of patent applications in India. I understand that the listener must be knowing about what is patent applications and what is the PCT, all these things. With that presumption only, I am discussing all these things. Now coming to the 10 global international, country-wise, you look at the things. Countries filed by the PCT route, to PCT route, maximum applications were filed by USA with 8,199, followed by Japan 3,607, China 2,601, Germany 2,099, Korea 1,492, Netherlands 1,079, UK 1,025, Sweden 1,008, Switzerland 983, France 949, Italy 507, Denmark 329, Israel 310, and Belgium 305. What does it mean? It suggests that, you see, how many foreign nationals, they are filing patent applications in India in national phase. If I'm talking about the PCT, through the PCT in national phase, these many applications were filed in Indian Patent Office. So in contrast to that, let me tell you, in the COVID-19, I have taken this video from WIPO. It is very interesting. You see, in COVID-19, first one was Denmark, followed by Sweden, Switzerland with 4,883 applications, United Kingdom with 5,912 applications, France 790 applications, 6th, 5th, Germany with 18,843.
सर आपके तरफ से म्यूजिक आ रहा है सर, आपके तरफ से म्यूजिक आ रहा है। जी जी, अब ठीक है जी।
China with 68,720 applications through PCT route via Patents Cooperation Treaty they have filed. What it suggests, in a single year in COVID-19, they have filed this much of applications for grant of patent in different countries. I'm not talking about India. That means you see how the countries are working even during the pandemic also. And then my next visit, my next video will also see from 2001 to 2020, the patent application filed by the country. You see how China has rose from 2001 to 2020. you can appreciate this. Even China has overtaken US in 2020 with 68,720 applications in a single year. I'm talking about. It's in WIPO. Again, this is I have taken from this WIPO. The source is WIPO. What it suggests that even as a country is filing through PCT applications some 68,720 applications in a single year in different countries through PCT route. In contrast to that, you see, what are the PCT international applications filed by Indian applicants during these 5 years? Because again, I have to rely upon the 2018-19 Intellectual Property India annual report. In 2018-19, both individual and legal entity together, they filed only 966 applications. You see, look at the things. By the Indian applicants in foreign countries through PCT routes. Whereas China, they are in 65,000 or 68,722 in only 2020. In 2017-18, the individual are 274 and legal entity at 493. Together, they come up to 765 applications only through PCT route. What it suggests, if a country of 130 crores people, 1.3 billion plus people, still we are not in a position to actually translate our ideas into patents. Even we are not in a position to file the patents. That is a sorry state of affairs, because on this day, on World Intellectual Property Rights Day, I have to assess when we are talking about the Atmanirbhar Bharat and if I am talking about the 5 trillion economy. In that case, can it be possible with this meager amount of innovation that are being filed by the Indian applicants in PCT rules? Now, this is an important statistics. If you go through year-wise, patents in force. If you look at 2014-15, the patents in force were 43,256. In 2015-16, it was 44,524. 2016-17, it is 48,765. In 2017-18, it is 56,764. In 2018-19, it is 64,686. What it suggests? You see, in 2018-19, only 64,686 patents are in force. But I don't know whether these patents, they are invention, because they have qualified that patentability criteria of novelty, non-obviousness, and utility, or in this TRIPS regime, we can call it novelty, inventive step, and capable of industrial application. And of course, they are part of the patentable subject matter. According to Indian Patents Act, non-patentable subject matter has been defined under section 3 and 4. So this 2018-19, 64,686 patents are in force, but how many of these patents are real sense they are innovative? If they are not being commercially exploited or commercialized, then there is no meaning of these inventions I'm talking about. Again, here also for Atmanirbhar Bharat, if I want to talk from a different perspective, we can convert these patents into commercialization by anyone interested, any entrepreneurs for that matter, because this year's theme is IPR and SMEs. Any SMEs can take a license, voluntary license from any of the patent holder, and he can commercialize those invention into innovation. But question comes whether those inventions are capable of commercialization or exploitation, commercial exploitation. That is a big question mark. Now it is an interesting, I'm talking about the statistics about, because now everyone talk about how many patents who have applications have filed, but how many they have been translated into patents. So the total patents filed by Indian universities or institutes during 2009 to 2019. It is I have taken it from the Rajya Sabha website wherein to a start question in Rajya Sabha, this was the answer given by the minister. He said that during 2009 to 2019, around 25,200 patent applications were filed. And interesting, you see, out of that, total patents granted were only 5,089 only out of 25,200. So what is the strike rate? If I am talking about the IPL, what we are playing, what is the strike rate? You see, the strike rate is not good. Only 1/5 patent applications are being converted into patents. So in that case, you see the performance of CSR is of course good, because CSR were granted 1,917 out of 2,413 patent applications they filed during this 10 years period. IITs totally they have filed 500, they have granted 519 out of 3,751 patent applications. Look at them. We are so much proud of our IITs. I'm not criticizing the IITs, but when it comes to the translation of these patent applications to patents, you see the strike rate is not good, because only 519 patents were granted out of 3,751. So in that sense, those rest of the patent applications, they could not fulfill the patentability criteria. So what is the meaning of this filing these patent applications? You see, DRDO granted 519 out of 919 patent applications filed during 2009 to 2019. And NITs, it is some on par with the IITs. Only 11 patents were granted out of 2,016 patents they were filed, patent applications that were filed during 2009 and 2019. This may be because there is a pressure always from the UGC and other granting body that when they are giving some grants, they are asking how many patents you have filed, applications you have filed. Even now it has become part, everyone is working for NAC accreditation, everyone is there. One of the important criteria in the NAC also, how many patents applications you have filed and how many patent applications that were granted. If NITs, National Institute of Technologies, they filed 2016, out of 2016, only 11 patents were granted. What does it mean? For the sake of filing a patent application, I am filing because I have to enrich my CV that this much of applications are filed. But when it comes to grant of patent, only it is not being the true picture. Now look at the things. Then the question comes: in what way? What is the research and development expenditure globally? This is the most important thing, because in that I will, in contrast, I will discuss how much you are spending in India also. If you look at the top 5 countries in global on R&D, research and development spending, then United States stands at number 1 with 543.2 billion US dollars, China 496 billion US dollars, followed by Japan at number 3, 175.8 billion dollars. Germany with 127.1 billion US dollars, and South Korea, of course, with 89.8 billion US dollars. This I have taken from the R&D expenditure ecosystem of 2019 by EAC of the Prime Minister's group. Now look at the things. The top 5 countries global share of R&D spending. If you look at what is their global share as far as percentage is concerned, in that sense, United States has 31.9% of total R&D spending globally, followed by China with 29.1%, Japan 10.3%, Germany 7.5%, then South Korea with 5.3%, and rest of the countries, rest of the world I am talking about, with 15.9% only. You see, this is the sorry state of affairs. These 5 countries, United States of America, China, Japan, Germany, and South Korea, they together around approximately they are spending 84%, I can say. 84.1% of total global share on R&D, whereas only 15.9% are with the rest of world. So this is how you have to understand the innovation culture, because innovation culture plays an important role, how much you are spending on innovation. Now look at the things. The top 5 countries on R&D as a percentage of GDP. As a percent of GDP is an important indicator. In that case, in South Korea, it is spending 4.3% of its GDP on R&D, followed by Israel, 4.2% of its GDP on R&D, Japan 3.4% of its GDP on R&D, Switzerland 3.2%, and Finland with 3.2%. What it suggests, these countries are spending like anything on research and development. That is the reason they are becoming more innovative countries. Again, you look at the things when it comes to public expenditure in R&D by India. In that case, India's investment in R&D has decreased overall. The last decade from 0.85% of GDP in 2008-2009 to remain stagnant at around 0.7% for last several years. That means we are spending only 0.7% of our GDP on R&D. From that also we cannot expect innovation. This is significantly lower than the top 5 R&D spenders globally in 2017. So you should look at the things, because the highest being the 4.3% of the Republic of Korea, 4.2% of Israel, 3.3% by Japan, and 3.2% by both Switzerland and Finland, and lower than the R&D investment of other BRIC countries, which includes Brazil, Russia, India, and China. They together, if you took it together, then again they are far above than this BRICS country. Now, this is an important statistics. The top 10 companies with maximum R&D spend globally in $1 million. So in that case, you see Samsung. It is spending around 14.8 billion, because it is a million, but I'm converting into $1 billion. So $14.8 billion on R&D, followed by Alphabet, 14.8. Alphabet, you must be knowing, is a parent company of Google. Germany, Volkswagen, 14.5. Microsoft is spending $13.5 billion US dollars on R&D. Huawei of China, $12.5 billion. Then Intel of America, $12 billion, 12 billion US dollars. Apple, $10.6 billion US dollars. Roche of Switzerland, 9.8. Johnson & Johnson, a company is working on baby products mostly, and some of medicine pharmaceuticals, they are spending $9.7 billion on R&D. Of course, that is Daimler of Germany, 9.5. What it suggests, the countries, these multinational companies, they are spending on R&D globally. If you look at the things, this is the source I've taken. The source is there. You can also go through this particular source. Now, coming to the important aspect. Top R&D spending sectors is share of global top R&D spenders in 2018-19, because I tried my level best to get this statistics very clearly, recent statistics, but the statistics were available up to 2018 and 19. You see, ICT, that is ICT hardware and electronic equipments, in that maximum R&D is being spent, that is 23.5%, followed by the pharmaceuticals and biotechnology with 18.8%. Automobiles comes with 15.6%. Software and ICT services with 14.4%. Industrial engineering and transportation with 3.8%, so on. Why I'm discussing this, why I'm showing this thing? Because what is the R&D spending sectors? A share of global top R&D spenders in 2018-19. Now, another interesting facts I'm going to share with you. If you look the top 25 global brands by value and origin, as per the 2020 report, I think America has maximum number of brands, global brands, because it has Amazon at number 1, Google number 2, Apple number 3, Microsoft number 4, Facebook at 7, Walmart at 8, then 14th AT&T likewise, and followed by China. The value it is there, you can see in $1 million, but China has also 1, 2, 3, 4, 5, 6, 7, 8, 9 brands, global brands, which is part of this 25 global most sought after global brands as per the 2020. Followed by Germany is 2 important global brands in the 25 club. That is, first one is Mercedes-Benz at 11th position and 25th is Volkswagen. Republic of Korea is Samsung Group is at 5th position. Japan's Toyota is at I think it's 15th position. Netherlands Shell is at 23rd, and Saudi Arabia's Saudi Aramco is at 24th position. What it suggests? Not a single brand of India is also within the top 50 I'm talking about. So this is also, this global brands has also shown importance because that brands cannot come out without any innovation. So they are spending so much of money on innovation. So that is the reason how this brand value increases. And you see the top 25, out of top 25, America is more than 10 brands, followed by China. So wherever you go, anywhere in the across the globe, you will find these branded products, either of any of the gadgets we are talking about. You will find not a single Indian global Indian brand you will find which has some global outreach. Now, public expenditure in R&D. If I'm talking about Indian perspective, 12 major scientific agencies accounted for 99.8% of the R&D expenditure incurred by the central government in 2017-18. This is a report of 2017-18. So the central government is funding, that is public funded R&D, research and development. If you look at these things, out of this 99.8% that are spent by the central government on scientific agencies in India, 61.14% of this spent on R&D in defense only, defense, atomic energy and space, while the remainder was allocated as follows, that were 11.1% on ICAR, that is Indian Council of Agricultural and Agriculture Research, 9.5% to the Council of CSR, 7.3% to the Department of Science and Technology, 3.7% to the Department of Biotechnology, 3.1% to the Indian Council of Medical Research, ICMR, 3.7% to the Ministry of Earth Science, Ministry of Electronics and Information Technology, Ministry of Environment, Forest and Climate Change, and Ministry of New and Renewable Energy. You see, look at the thing. This is the bifurcation of the percentage of R&D spent on different ministries and the different scientific organizations. Now, look at the India's science, technology and innovation system. We have to understand the innovation, science and technology innovation system in India. So the overall structure of the research system of the country is constituted by 4 main factors. The 4 main factors are public research system under the government and public enterprises, academic research system and universities, private research laboratories under the business enterprises, and non-governmental research institutions aided by both public and private sources. The central government, S&T department, independent research institutes, in-house R&D in private industry, science and technology in non-government organizations, state government science and technology department, and central socio-economic and other ministries. You see, here again I am taking you to a beautiful diagram. This is the network of public funded science research in India. The amount I talk about, 99.8% of the R&D is being spent over these institutions. This institution, we have a Science in India Academy. If you look at the things, we have a Ministry of Human Resource and Development, under which comes University Education and Central University, technical educations that are IITs, triple ITs and NITs, science education that is IICs and IJs. Then in the Ministry of Science and Technology, where the Department Science and Technology, DSR, CSR, Department of Biotechnology, Department of Atomic Energy, Department of Science and ISRO, Atomic Autonomous Research Organization. Again, in Ministry of Defense, we are having DRDO, Ministry of Health and Family Welfare, we are ICMR, Ministry of Agriculture, we are having ICAR, and state government university and labs. This is actually the map of the public funded research, science research in India. Now coming to the most important part of my discussion is, if this is so, what about our university, how the university, our universities are performing? No doubt this Times Higher Education World University Ranking has come out with an impact factor recently. Many of the universities have found their place in global rankings, but overall rankings I'm talking about, not on the, as for the SDG. Sustainable Development Impact Factor rankings I'm not talking about. We're talking here. The Times Higher Education World University 2021 has come up. In this, you look at the things. The University of Oxford is at #1 position. It is from United Kingdom. You see how many universities are from United States and how many are from United Kingdom. At the second position is Stanford University, third Harvard University, fourth one is California Institute of Technology, fifth one is Massachusetts Institute of Technology, sixth is University of Cambridge, seventh is University of California, eighth is Yale University, ninth is Princeton University, and 10th is University of Chicago. Out of this 10, you see, first top 10, only 2 universities are in United Kingdom, rest are from United States. Now, from 11 to 20, you see, again, at 11th position, Imperial College of London, United Kingdom, Johns Hopkins University, United States, University of Pennsylvania, United States, ETH Jurist, that is, of course, from Switzerland, then University of California, United States, UCL, United Kingdom, Columbia University, United States, University of Toronto, of course. This year we have found that Canada, one of the Canadian universities at the 18th number, at 19, Cornell University, again United States, and at 20th, Duke University, United States. And of course, again, there is a tie between the 20th rank, and that is the Tsinghua University of China is also at the 20th position. And again, China has another university in top 25, that is at Peking University of China is 23rd. So they are having 20th and 23rd ranking university. And of course, Singapore is at the 25th rank world Times World Higher Ranking as per the Times Higher Education. Now coming to the Indian universities, you look at the things. We are so much proud of our Indian universities and institutes. We look at the thing. Indian Institute of Science, Bangalore, is between 301 to 350. I'm not talking about the present recent impact factor as per the SDG. I'm not talking about things. Overall, I'm talking about. And the Indian Institute of Technology, Roper, is between 351 to 400 rank. Indian Institute of Technology, Indore, is between 401 to 500. And rest of the 7 universities or institutions, they are falling in between 601 to 800. There it comes Banaras Hindu University, Indian Institute of Chemical Technology, Delhi, University of Delhi, Delhi, Indian Institute of Science and Education Research, Pune, Indian Institute of Science Education Research, and Indian Institute of Technology, of course, Gandhinagar, and Indian Institute of Technology, Hyderabad. This is the university ranking. Globally, I'm talking Indian University in Times ranking 2020. With this, let me stop because it will go and go and why? What is the purpose of this assessing this innovation culture? Because as I said that this innovation culture has a lot to do with grant of patents. If you don't have an innovation culture in India, from where innovation culture comes? It comes from the education system. It comes again from that way, it goes to the research and development. You must have good research and development institutes. Then there has to be a funding from the government also. That is also most important thing. So from government, again, you have to see that how many patents applications were filing. So what is the actually ground money, the infrastructure the researchers are getting. So from this, you can assess that whether with this kind of innovation culture, can we achieve Atmanirbhar Bharat, or you can reach to the 5 trillion economy, because I have seen that many of them, like Amazon is more than 5 trillion economy. It has its turnover is more than 5 trillion. We are talking about the 5 trillion economy by 2024. So time has come to introspect ourselves. So if you want to go for an Atmanirbhar Bharat, and we have to achieve this, we want economic development to put ourselves in the global innovation index, then we have to improve our global innovation index also. Let us hope for best for the, I am not that much a pessimist, I am very much optimistic that we can do. Only thing is, when we are having 135 crores people are there, only 1% of their ideas can be converted into patents. It will be a miracle, until frankly. Only thing is, we require that sort of infrastructure, that sort of willpower, that sort of mindset, that sort of attitude, and that sort of support from the government. That is an important thing, because I have seen how small countries like Switzerland with 56 or 86 lakhs people, they are the #1 innovative countries. Here we can also do. I am not saying that we cannot do. Only thing is, we have to introspect ourselves and we have to rethink. Of course, let us see that the new education policy has come. We are going to introduce how come this will improve our innovation index. Let us, it's a matter of fact, we have to see over a period of time. I think I should not discuss. I am not going to give you a very gloomy picture, because what I have said is more of not a rosy picture I am talking about on this global, this World Innovation Intellectual Property Rights Day. But somewhere we have to, time has come that we have to introspect ourselves, and that's the reason I have chosen this topic of assessing. I'm just assessing with the facts and figure. I'm not any outsider. I can do wonders, and I don't have that magic wand that I can turn into everything. No, but we have to find out that we have to introspect. If this is the system, can we achieve Atmanirbhar Bharat? I'm not, because I'm much fan of this Atmanirbhar Bharat. We have to be in Atmanirbhar in every sense. And there are many intellectual property rights, and we can do wonders. I have given 2 lectures on GIs, that is geographical indications. It is one of the important area where we can explore. There is a lot of thing you can explore in exploring these GIs, where we can achieve Atmanirbhar Bharat, or there is a chance of rural development also. So we are living in a 2 extremes in India. There is a disparity between the rich and poor is so much. The bridge is so long, it's very difficult to bridge them. So I think this intellectual property is one of the important area through which we can do wonders. With this, I think I should stop here, because I should also, at the same time, I should also look forward for questions also. That is why I am here. And at the again at the end, I should not fail in my duty if I am not thanking Professor Yugal Kishore Sarji, Professor, the Dean of ICFAI Law School, giving this opportunity to share my views actually on this World Intellectual Property Rights Day. It is one of the important area, my dear friends. All the budding students should understand what innovation means. For that, of course, and clear understanding of patents is most important thing. Without understanding patent law, it is very difficult to appreciate. But anyway, some other day I will discuss the intricacy of patents, how it works. That is also an important area I will discuss later on, because it's Yugal Kishore sir has been very kind enough to me. Of course, he's giving, whenever he's getting a chance to call upon to share my views in their platform. With this note, let me stop here, and I'm looking forward questions from the audience. Thank you. Sir, it has been muted, sir. आपका mute है.
I'll say, हाँ. Sir, बहुत बढ़िया lecture था आपका, बहुत मजा आया. It was really very informative with the all data. I'm so happy.
Sir, thank you very much.
ठीक है, question ले लीजिए. सौरभ जी, questions ले लीजिए.
Sir, I would start the question from the very first Professor Dr. Actually, there are questions that revolved around trademark, of course, Participant Samriddhi Garg asks, Miss Samriddhi Garg asks that how is Trademark Act 1999 is different from Trade and Merchandise Marks Act 1958?
That's what actually. Saurabhji, thank you. If you, the student has studied the preamble, how it is different from the Trade and Merchandise Act, and how the Trademark Act 1999 gap was there. The preamble itself specify the gap actually. That's what I told. Okay, yes, the purpose is just to enact, just to amend, and to consolidate. It means that gap was there. Even the registration, that gap was there. Specifically, a simple example I give you. Okay, that was Information Technology Act actually. That was the main concern actually, bringing it as a graphical the representation, ensuring that the product must be the graphical representation.
Sir, one question from my side, sir.
Yes, please.
That often we see there are suggestive marks, but there are also certain trademarks which are registered which does not suggest the product or services. Like a fine example is Apple. Apple does not suggest for an electronic product. So what should be the ground for actually, if only distinguishing would be the only one ground, or morality would be another ground? If, sir, morality would have been one ground, then this Lakshmi brand beer, it was there in Australia. The case was very much revolutionized. So how to strike a balance on approval of the marks?
Specifically, very rightly, you have raised the query. Actually, if we say the Apple, actually, Apple is considering Apple do not indicate that particular vegetable. Actually, otherwise the message goes it is that Apple actually, where it is a generic word actually. On the other hand, when we go for the morality side and even Section 9 specifically absolute discuss about the absolute even if it is against the statute, if it is against the say which is at least which is not conveying the meaning actually, or somewhere some morality is involved, so that is total refusal actually. On the other hand, Section 11 and Section 12 we say, even the Section 12 what says, okay, even the concurrent user, if you do not have any objection, the two parties, two proprietors, they can continue having the concurrent user using the same trademark. But is it possible in the today's era? We are competitively growing and there is a cutthroat competition in the market actually. Somewhere directly or indirectly, sometime my product and your product may not be sometime very similar. I will try my best to give best and to present myself better than you. So similarly, that means academically it is correct. Given, it is given actually Section 12. But how far the practically it is applicable Section 12? The question is that. So even the flexibility is there under Section 11. Like I was discussing about the COVID trademark, 150 marks are there, which has been registered actually and filed an application. But simply COVID has become that mark, the custom mark, which traditional, it has become traditional use now. So we cannot say to whom, how many people they can claim for the COVID mark, prefix or suffix. No, it should be different.
Thank you.
Huh?
Thank you.
Like Sputnik, yes, Sputnik is a different. Go for that innovation. That's what Professor R.K. the Rathore Sahab has stated. Of course, we self-promote the SMEs, but some innovation must be there. Go for Atmanirbhar. We are supporting the Atmanirbhar. Let ideas must be there and let's try to execute those ideas. Thank you. Sarojji.
Thank you. Back to Rathore, sir. There is a question like when we talk about Atmanirbhar Bharat and the patents that has been filed, actually in quantity it has been filed. But since there is a lack of patent valuation culture in our country, we don't do much of the intellectual property valuation. So IPR management is non-existent, in fact, in our Indian companies, and it is very less taught also. So, sir, having said that, very less quality patent has been filed by I guess our universities all over the country, and even CSIR also faces rejections. So, sir, how would you suggest that there should be a roadmap to properly value the IPR which is generated? Whether we need a nodal office or how, or the cooperative society's role, how to proceed with that, sir?
The question is to me, I think. Of course, yes, we don't have an IP management in India, and most of the companies also. I'm not talking, it's making a general statement. Most of the countries also, they don't have an IP management. They are very conservative. But as I said, this intellectual property is very costly affair. Even if you are getting a property, intellectual property, to manage it is a very costly affair. I'm telling you, it's like a white elephant. If an infringement applications you are filing in any foreign countries, I think you will run through crores of rupees which we cannot afford. You see, for simple example, we the CSR fought for this basmati rice, and we spit out around $10 million for this protecting this basmati rice. So it's a costly effort I'm talking about. But my point is that you have rightly pointed out that we are still, I'm not saying that I never undermine the people's mind in India. I've never undermined. They are not getting that right kind of infrastructure or logistic support or the support from the government and R&D. In most of the cases now, Indian from a government point of view, they are shutting out this R&D because they think that it's a white elephant. In most of the cases, even the private companies, they're outsourcing the R&D. You come with idea, we're going to pay you. You see Mahindra, what it says, you come with an idea, I will going to give you $1 billion. That's why I am not going to spend on R&D. What will be the outcome, I don't know. This is we are working in a phase, an era where there is a lot of competition. Now, there is only thing is we have to think innovative way. For that reason, I think somewhere this education system doesn't support that innovative idea. Right from the schooling you have seen in India, in most of the cases, even IITs also have seen, getting an admission in IIT is a very Herculean task in India. Once you get IIT admission in IITs, I think I should work for a multinational company, but I never think of it to become an entrepreneur, most of the cases. So we are more towards the working as an employee, not as an employer or entrepreneur. That mindset has to be changed. That attitude has to be changed. For that reason, of course, there has to be funding from the government. Now the way the government is supporting the startups, you see, that's many of the startups are doing wonder. And most of the institutions and universities are coming out with the startups. And I think my university, Gujarat University, is one of the best startup incubator as far as in country is concerned. Because there are, you see, the government has everything. This Atal Startup Mission is there. You see, funding is there. Somewhere again, I think that bureaucracy is there. That system has to be dismantled. Otherwise, I'm very much sure. We have ideas, but even if I'm having ideas, but I'm not getting that kind of support, both resourcefully from the human resource or for the financial resource, I'm not getting. So the government is also many times skeptical, because why should I spend on so much on this? What should be the outcome? Okay, fine. The strike rate, because if you look at the strike rate of the conversion of the patent applications, the patents, you see it is only 1/5 only, 20% strike rate is there, because I have shown you that out of 25,200 patent applications by the universities and institutions, only 5,000 patents were granted. So what about the rest 20,000 patent applications? That is also big question mark. So we have to rethink. I'm not saying I said now I'm too much optimistic. I'm not saying that I'm pessimist that we can't do anything. We can do. we can do wonders, because anything, you see, at the end of the day, when it comes to idea, I am borrowing this idea from the common only. If you believe the Lockean theory, John Locke, who is a papa on the labor theory, he says everything is in common, you have to make it private. And intellectual property is my private interest. You see, why then question comes, why the government is protecting my private interest? You see, important thing is why? Because it is entering an agreement on behalf of the state with the intellectual property right owners, that in lieu of you are giving the disseminating the knowledge, we are going to this much of royalty. So that incentive, again, I am saying that people are not working in patents in force. There is a lot of scope for entrepreneurs. They can go for some of the patents that are there idle in the fridge or the cold storage, and we can commercialize it. That sort of, there again requires some sort of incentives or some sort of help from the government. That is also most important thing.
Sir, another question is that how can we have Atmanirbhar Bharat or innovation if innovation patent does not exist? In exception of pharmaceutical, we don't have innovation patent in product patent or process patent. So how to culminate this culture of innovation when we have to invent rather than innovate?
Now, you see, I said invention is one thing, innovation is another thing. Yes. Invention is when you are fulfilling the patentability criteria, you can get a grant of patents. That is invention. A new invention that you can go through the Patents Act, you can understand. But innovation is commercialization of that innovation is most important. Invention is most important thing. Many times also we are not in a position to commercialize those patents that were granted. That is the reason I can say we can explore in that area. Somebody has to come out and explore those things, and we can take voluntary licenses from the patent holders. Because again, at the end of the day, the patentee, if he's not in a position to commercialize, is useless again. So the only having a patent in my name is useless, I'm talking about. So it has to be commercialized either through me or by somebody else. And that is the reason this intellectual property has very beautiful system. You can, there is a licensing agreement is also there. You can, through licensing agreement, you can license that particular patent to any other person. For a particular country or some of the countries, you can do wondrous things. Point is that somewhere we are lacking that. So a time has come. We have to understand this intellectual property in total. We have this intellectual property to understand the potential of this intellectual property I'm talking about. Because if you look at this year's the theme of this WIPO, World Intellectual Property Day, that is IPR and SMEs. You see, SME is one of the very big area I'm talking about. Of course, Professor Vatsar has already talking about the trademark, and trademark is one of the area through which you can also earn money. This you can by making a brand value, that also. But when many times I have seen, because one of my student is working on that only, we have seen that many times these SMEs, particularly medium enterprises, they come out, but they are filing the patents, but the patents is not up to the mark of grant of patents. For that, there is another area we are not exploring, that is petty patents or that is utility models. You see, if you go through the WIPO site, you can see how other countries are exploring these utility models that are petty patents, where less patentability like criteria are there, but they are not that stringent I'm talking about. So that is another area, and the monopoly is up to 10 years only. So that is, we Hindi guard jugaad hum bolte hain na. Jugaad is one of the area, because we are very much fond of jugaads, and we can do any. This pandemic also I've seen many jugaads. You see, many innovative ideas have come. आपने कभी देखा था कि innovative ideas ऐसा आता है? For the first time in pandemics, we have seen that there are many jugaads have come out at local levels also. So now question comes that we have to work upon the, if we want to work upon the jugaads or the petty patents, we have to go to the grassroots level. So from grassroots to global, that is how can we enter the global market. I think that is one of the area in SMEs we can work upon, that even if we are failing in the granting of patents, I think the petty patents is another area where we can explore, which has not yet been explored. The reason behind, we don't have a specific law. So one of my research is working on a sui generis system, like plant varieties, right? We can have a sui generis system of protecting these petty patents or jugars in India, because most of the countries, developed countries, they are reaping very much on these jugars only I'm talking about. So we cannot wait for so much money in investment, because patent requires a lot of investment also. When you are talking about the pharmaceuticals also, few pharmaceutical product patents are with us. So, and again, we have to find out certain areas where we can do well. We should not only work upon only the pharmaceuticals, because most of the pharmaceuticals in India, they are generic companies only. They are producing generic medicines only, with an exception or one or two. Thanks to this COVID-19, we are the first in Covishield or Covaxin. In that, I'm not undermining the pharmaceutical countries, but we have to find out other avenues also. Biotechnology is another area we can work upon. That is an important area, but we have yet to explore that biotechnology in its fullest sense, I'm telling you. So you see, in that case, from very in the beginning, we have to work upon that, because in that way, you have to teach the students. आज के तारीख में we have seen that when you are doing well, we are looking for a foreign degree only. We are going foreign. That's why we don't have that system to protect our own students in our own country. So best minds are going away. So then that is the important thing. One has to work upon that also. You see, even in the ICT, you see all this Silicon Valley, they are doing wonders. But you see, the 30 to 40% are Indian scientists. So we can do, but we are the scientists, maybe we are not getting that. The government is to think upon what to do. You must have a roadmap for another 10 to 20 years. Niti Aayog is working on that. They have come out with a national innovation policy, all these things. But how it has been worked upon, that is a big question.
Thank you, sir. Over to ma'am, Ekta ma'am. Ekta ma'am.
Thank you so much, sir, for providing such an informative session. Now I would like to take this opportunity to invite Mrs. Monica Kharola, ma'am, Academic Coordinator, ICFAI Law School, ICFAI University, Dehradun, for vote of thanks. Over to you, ma'am.
Thank you, Ekta. It was a wonderful session, and the IP cell has very timely brought in this, address by our speakers today, Professor Dr. Naresh Vats, who talked about trademarks and how it is important for the consumers also not to be, not to face difficulties in choosing the correct product, and also how trade secrets can be utilized for promoting the interest of the businesses, because today protecting knowledge and intellectual capacity is what is leading to more innovation. And like the second speaker, Professor Dr. S.P. Rathore said, that India needs to be proactive in terms of encouraging innovation in India, and therefore enhancing our patents, and firstly application of patents, and secondly is the utilization or the commercial application of those patents. And it is true that we have a lot of potential, and if given the right environment, our scientists are doing wonderfully well wherever they are going. So India needs to look within for what are the causes, reasons for deficiencies, because if small countries like Korea and Singapore can do excellently well in these areas, India has a lot of potential. We must also encourage this scientific temper from the school itself, and therefore maybe the national education policy which has come up will be very productive and fruitful towards helping students to have a scientific bend of mind in order to have the culture of thinking new and trying to bring more relevancy to the education to see how it can be useful to mankind. So with this, we thank both the speakers, Professor Dr. Naresh Vats and Professor Dr. S.P. Rathore for giving their time and giving us this important talk on the importance of intellectual property. I thank the IP cell, Saurabh and Ekta, for putting the program together, and I thank Director Sir for guiding us in this. I also thank the Vice Chancellor for always motivating us to take up new challenges, and I think we should work towards enhancing the intellectual property capacity of India with positive actions at every level, beginning with school, college, and even in personal lives, where Professor Rathore said that even the petty patents which we can work on will be productive. So thank you for being here, and thank you to all the participants for being with us. Thank you. Over to you, Ekta.
Thank you so much, ma'am. Now I would like to invite Professor Dr. Yugal Kishore to end the session.
Sure. I'm very much thankful. I'm very much thankful to Ekta Madam for giving me the opportunity. First of all, to our Professor S.P. Rathore Sahab. In fact, in your absentia, we welcomed you, and we have given you that particular bouquet also. So please accept now, because that time you were not here. I understand you had 2-3 meetings. You told me that you will not be available. But even then, I'm so much grateful to you and thankful to you that despite such a busy schedule, and even at such a short notice, you have accepted our invitation, and you have given a wonderful lecture. Of course, both of you have presented very well. And sir, I tell you, today's your special guest lecture by both of you was really very, very wonderful, very informative, and very much thought-provoking. And in fact, its proceedings should be written and sent to the government of India, because something more should be done. As S.P. Rathore Sahab has rightly said, that we need funds, we need encouragement, we need motivation, which we don't have in our country. Research and development is zero. Of course, to some industries, to some organizations, they have it, but in our universities, it's very less. And sir has very rightly said that even the very universities like IITs and NITs are not doing that well. And our Professor Nareshwar Sahab has rightly said with regards to the trademark that still deception is going on very much. And so therefore, from the core of my heart, I'm thankful to both of you that you have spared your valuable time and you are here with me today. And because of you, this ICFAI Law School and ICFAI Center of Intellectual Property Rights could not only celebrate the Global Intellectual Property Day, but of course, very successfully, in a very positive way, it could understand, it could get certain insight, it could get certain encouragement to work on IPR. So I'm very much thankful to you with folded hand. I thank both of you, sir. And
sir, I'm honored.
So thank you.
Sir, I'm honored.
Thank you, guys.
Next time again, कभी आप लोगों से मुलाकात यहाँ पे जरूर होगी, हमें मिलेंगे तो और भी अच्छा लगेगा.
सर जरूर आएंगे सर, आपसे मिलेंगे.
जरूर सर.
I'm really, it's a misplaced honor for me anyway. I love your beautiful words for me. I always, this intellectual property rights has always been very near to my heart, because I am teaching this since 2005 at master's level. We are offering LLM in intellectual property rights with 12 exclusive papers on intellectual property rights. Though I have been assigned the duty of heading the Department of Environment and Legal Order, still there is always a space for intellectual property rights. Wherever when intellectual property rights discussion or discourse is there, I am always available there. So thank you very much for giving this opportunity And this is I'm honored, and this is a great privilege for me on this platform to share my views. And with that again, with Professor Naresh Bhatt, though I could not attend the first lecture because I was otherwise busy with some board of studies and faculty meetings of other university. Anyway, sir, I miss your lecture, but I have seen I can go through the this YouTube and I can listen your lecture. Thank you very much.
Thank you, Rakesh sir. This is the e-flower bouquet to you. Hi, Professor Yugal Kishore sir, and thank you, sir, having together on the virtual meet. Keep in touch.
Sure, sir.
Keep in touch, sir.
Sure.
And certainly we'll have some academic platform. Yugal sir, thank you so much. Saurabh ji, Ekta ji, and every colleague, Monica ji, thank you. Convey my regards to Vice Chancellor Saab and every your colleagues. Thank you, sir.
Yes, sir. Thank you,
sir. Thank you so much. Stay healthy.
Very kind of you, sir. Thank you very much. Thank you very much.
I express my thanks to, of course, Saurabh and Ekta, and of course Monica ma'am, because last time also I was there on a different on leveraging the intellectual property rights patent regime for medicines. I've discussed in the last year also. On this was also again on COVID-19 situation I discussed. At that point of time also Monica ma'am was there, and my special thanks to all the team. I'm happy that Professor Yugal Kishore is having a very young and energetic team. That makes a lot of difference, because lot of things they are doing down the year I have seen. Every alternative day there is a webinar I have seen by this ICFAI Law School Dehradun. Hats off to of course Professor Yugal Kishore Sarji. Thank you, sir. With this note, thank you very much again.
Thank you, sir. Thank you. Thank you. Stay healthy. Thank you.
Thank you, sir. Thank you, sir. So now I think we can close, sir. So now we can close, madam. Okay. Thank you. Thank you very much. बहुत अच्छा लगा.